नाजरीन, आप देख रहे हैं हालात का यूट्यूब चैनल और मैं एम अबू बकर आपसे मुखातिब हूँ। साबिक चीफ जस्टिस ऑफ इंडिया AM अहमदी मेमोरियल लेक्चर से खिताब करते हुए सुप्रीम कोर्ट के साबिक जज RF नरीमान ने कहा कि बाबरी मस्जिद तनाज़ा मामले में सुप्रीम कोर्ट के जरिए सेकुलरिज्म की धज्जियां उड़ाई गई है, इंसाफ के साथ एक घिनौना मजाक किया गया है। उन्होंने अपनी तकरीर में कई अहम मुद्दों पर बाबरी मस्जिद और राम जन्मभूमि तनाज़े के मुख्तलिफ पहलुओं पर रोशनी डाली। आइए सुनते हैं उन्होंने आज के इस तनाजुर में क्या कहा।
Was that secularism was not given its due at all by these judgments, and as I told you, they've spoken in different voices. First two voices, then the second two voices, my voice and the voice of the five-judge bench. But there is one very important silver lining in all this, and that is the Places of Worship Act. Now, this act was specifically brought, as I told you, in the year 1990, in order that we do not have the Greek god of Janus governing us. What do I mean? Janus is two-headed, as you know. He's a Greek god. One face looks to the past, one face looks to the future. And because one face looks to the past will determine the future. The Places of Worship Act is the exact opposite. It is the Janus face looking behind is effaced. You will not look to the past. You will not try to counter historical wrongs by breaching the rule of law or by asking courts to do the same. And this very constitution bench spends 5 pages on it and says that it sounds in secularism, which is part of the basic structure, that you cannot look backwards, you have to look forwards. And what does the act say? Very important. Every religious place of worship frozen to 15th August 1947. Now, anybody who tries to change this, and if there are suits pending at the stage of the act, which is in 1991, those suits will stand dismissed. Abate. If any suit says that the character has been changed, the suit will be disposed of in conformity with this act, which is the same thing, ultimately. And importantly, therefore, we have this frozen position as of 15th August 1947, so that short of Ayodhya, which was kept apart as a special case in those Places of Worship Act, all other places will at least be safe. And we find today, like hydra heads popping up all over the country, there is suit after suit filed all over the place, now not only concerning mosques but also dargahs. And according to me, the only way of countering this, because all this can lead to, is communal tension and disarmament, contrary to what is envisaged in both our constitution and in the Places of Worship Act. The only way to scotch all this and to cauterize all these hydra heads is by applying these 5 pages in this very judgment and having it read out before each district court and high court, because these 5 pages is a declaration of law by the Supreme Court which binds each of them. And once this is done, it is clear that the Places of Worship Act will take its due course. One other important thing, the minority judge in the High Court, Justice Sharma, had opined that this Places of Worship Act, as a matter of fact, does not operate pre-1991. So that if there's a conversion pre-1991, that won't be hit by the act. The judgment goes on to say this view is completely wrong and in the teeth of Section 4.2 of that act. So if this act were to be applied as stated in this judgment itself, it will easily cauterize all these hydra heads, which are now popping up one after the other every day today. And I may only end by saying that in Justice Chinnappa Reddy's words, unless this is done, what he said will not come true. He said in the great Bijo Emmanuel case, our tradition teaches tolerance. Our philosophy preaches tolerance. Our constitution practices tolerance. Let us not dilute it.